Good afternoon, I'm Carrie Hunt, NAFCU's General Counsel and SVP of Government Affairs. Today I'm here as promised to give another update on what's been going on with Interchange. We had a hearing this afternoon on continuing matters in the Interchange lawsuit. First, let me start with the good news. The Federal Reserve indicated that they will file an appeal today of that district court decision. That's certainly something that NAFCU has supported and we were hopeful would come to fruition. So we are glad that efforts in that regard have been positive. So what the Federal Reserve said, that they want to request an expedited appeal, so they hope to have this matter resolved relatively judiciously. In the court world, that can be still up to a year before arguments are made, and then by the time you have a judge's decision, that could potentially be even longer. Now that we know the Federal Reserve is going to appeal this decision, what does that then mean? And there's still some tangential issues that need to be resolved. First, what happens while this appeal is going on? Now, the Federal Reserve said that they are requesting what's called a stay pending appeal. And this means that they don't want anything to go on in the lower court until the outcome of the appeal is decided. Now, and the merchants in court today indicated that they would support that stay. And the reason they gave for that is that they think that having another set of rules in place, or even the lower court just vacating the decision and going back to the pre-Durbin world, could potentially be more disruptive to merchants. So they, for those stated reasons, would support having a hold in place until an appellate court can decide whether or not Judge Leon had the right decision in that interchange ruling. Now, Judge Leon also still wants the parties to resolve whether or not there should be an interim final rule. And this was an issue that he had raised both in his brief, in his final court opinion, and also in court last week. The Federal Reserve indicated that issuing an interim rule was not their preferred course of action, that they felt that it prejudiced their appeal. The merchants indicated that they certainly would support an interim rule, but if an appeal is going on, they also were concerned about potential disruption. So the court has ordered that the parties brief this issue. So by the 28th, we'll see some additional filings as to whether or not we should have a stay and whether or not an interim rule should be put in place. And the amici in this case, of which NAFCU is one, along with our trade partners, potentially will file an amicus brief on those issues. Now, last week, the judge also raised the issue of damages. That issue is still potentially a live issue, although the merchants expressed today that they had not asked for damages in this lawsuit and questioned whether or not there was authority under the Administrative Procedure Act to even grant relief in that regard. So there's still a number of legal issues to be resolved on the lower court level. There's now a separate track relative to the appeal in a different court. So we will continue to follow developments in both regards, and ultimately I think that this has been positive today for credit unions, and NAFCU will continue to be vigilant in making sure that we get a positive result for our members, whether it be with the courts, whether it be with Congress or the regulators, and we'll continue to push in that regard. If you have any questions, please feel free to call me, 703-842-2234, and we'll continue to keep you updated via NAFCU Today and via our direct member communications. Thanks a lot.